Welcome, everyone. My name is Dr. Alicia Cohen, and I'm the director here at the Hubbard School of Journalism and Mass Communication at the University of Minnesota. I'm joined here today by my colleague, Professor Jane Kirtley, who is the Silha Professor of Media Ethics and Law, and also the director of the Silha Center for the Study of Media Ethics and Law based at the Hubbard School, which is funded by a generous endowment from the Otto and Helen Silha family. She is also the former executive director of the Reporters Committee for Freedom of the Press. Thanks for joining me today, Jane.
Thank you.
Our plan today is to focus the conversation on First Amendment rights and responsibilities, as well as on professional ethics involved in the insurrection at the Capitol and the events that followed, curbing former President Trump's social media activities and in consideration of the impeachment activities to come. Many of you who are listening have not taken a class in the Hubbard School or in journalism. And some of you might wonder, how do you prepare students to be journalists in the environment that we are experiencing today? How does the School of Journalism teach students about the First Amendment and the rights and responsibilities of journalists and media organizations? Today, we're prepared to answer those questions and others and to share them with you. As the host of this event, I need to go over a few logistics to make sure that you can participate with us. First, this is a secure webinar that is being recorded. We do plan to upload the recording to our website and to share it on social media in the next week. Second, Professor Kirtley and I will go ahead and talk for about 30 minutes. I've prepared a series of questions for Professor Kirtley to share her expert opinion on that, and also we'll be responding to a few questions that we received prior to the event. However, we also do plan on answering questions submitted that you might have for Professor Kirtley. We will answer many of those questions live, or as many as that you can. You may ask questions by typing them into the Q&A box. If you look at the bottom of your screen near the participants, you can see Q&A. If you click on it and type your question, you can type it and both Professor Kirtley and I can see it. You can do so by your name or anonymously, whatever makes you feel most comfortable. You'll note that there's no chat function available during this webinar. This is so that we can focus on the questions and the topics that we've selected for today's conversation. So without further ado, I'll go ahead and ask my first question, Jane. So President Trump has been charged with and will be defending himself against articles of impeachment. And the charge has been that he has, among others, that he's incited violence. Can you talk to us about when is speech that incites violence not protected by the First Amendment?
Thank you. And let me say welcome to everybody who is joining us today. It's a real pleasure to have a chance to share some ideas and some facts about some of these legal issues that have arisen in the last couple of weeks. The Supreme Court of the United States is very protective of anything that falls under the category of political speech. Some scholars say that political speech enjoys the highest level of protection under the First Amendment. So this means that the court is very reluctant to allow there to be any kind of sanction or punishment for people that are engaging in what can be characterized as political speech. It was relatively recently that the Supreme Court actually came up with a test for what constitutes incitement under the law. It arose in the context of a member of the Ku Klux Klan who was giving a rather incendiary speech in a field in Hamilton County, Ohio, using a lot of ethnic slurs and talking about taking what he called revengeance against certain minority groups that he had issues with. He was charged under an Ohio law called an anti-syndicalism statute. And some of you, especially those who studied French, know what I'm talking about when I say that. These are laws that basically date back to the turn of the last century and had to do with the rise of the labor movement and the fact that some of the unions and others engaged in violent acts where they were basically trying to upset the system of governance. At least that was the theory under which these laws were passed. So they used this law, even though this guy from the KKK was not really engaged in the labor movement. He was engaging in plain old kind of bigoted speech. He was convicted under the Ohio law, but it went to the US Supreme Court. And although the court did not overturn that law, they did say that he could not be convicted under incitement theory because under the incitement theory, abstract advocacy is protected by the First Amendment. It only becomes true incitement when your speech is directed to producing imminent lawless action. And is likely to incite or produce such action. So you have two elements here. And a lot of political speech can obviously be very inflammatory, but because of the nature of how and when it's delivered, it's unlikely to cause people to act immediately. And without that imminence element, you can't have a conviction under incitement under the First Amendment. It also has to be likely that someone is going to do that. And so as I think back over the events of January 6th, and I've said this to several of my colleagues, when I teach incitement in the media law class, the example I always used to give before January 6th was, if someone is standing in front of an armed mob and saying, let's go and take the Capitol, and you have a reasonable expectation that this armed mob is going to do it, that's going to be incitement. I'm not sure I can use that example anymore. At least I'm not sure I'll be able to use it until we find out what the ultimate ruling will be over whether President Trump actually incited imminent lawless action or not.
So how are legal scholars talking about this issue, that the question that did President Trump incite violence with his speech on January 6th?
Well, I think it's important to remember that the scholars and other legal experts are actually looking at not only the speech that he gave on January 6th, but some of his social media and other speeches that he engaged in prior to that time. They're saying you have to look at it in context, that it's not just a question of what he said on January 6th, where it was arguably a mixed message, where he said, let's all walk down to the Capitol and cheer on the senators we support and things like that. Whereas previously, he was tweeting things like, we have to take back our country. Be sure to be in Washington on January 6th because it's going to be wild. And if you put all those pieces together, the argument goes, that means that what he was saying on January 6th, while it might not on the face of it constitute incitement combined with the others, it would. There are other scholars who say, no, it's not. This is that same kind of historically protected rhetorical hyperbole. President Trump is just as entitled to protection for that kind of speech as anybody else would be, and that therefore it's not incitement.
And so if we think about what we might expect to hear from Trump's lawyers in the impeachment proceedings, they'll clearly say that Trump did not commit a crime of incitement and that his words are protected. Are there other variations you might expect to, or other legal precedents that they might rely on to make this claim?
Well, I think the threshold question is going to be whether this incitement actually, or this impeachment is actually permitted under the Constitution. Trump's lawyers are arguing that now that he is no longer in office, this is not an appropriate vehicle to use to sanction President Trump, that there may be other ways, like through the criminal justice system, but it can't be done through an impeachment. We'll see how that ultimately plays out. But there are a number of other claims that could have been brought against the president. And if you look at the article of impeachment, which really just talks about incitement to insurrection, and I think we have to pause for a minute and think about that. Incitement to insurrection, that's a huge, huge allegation to be making against the former president of the United States. And we really haven't faced anything like that in this country. People concentrate on the fact that we've impeached two other presidents besides President Trump, but there have been many, many other impeachments of federal officials over the last 200 or so years of this country, mostly federal judges, although not exclusively. And a couple of them were impeached after they had left office. So I think it's fair to say that there is precedent in the overall sense of how impeachment works to say that it would be acceptable to do this. But again, we will have to see how that plays out. I think one thing that you and I had talked about that I wanted to mention right up top is that President Trump does not have to be convicted of a federal crime in this impeachment proceeding. the impeachment language in the Constitution is quite broad. It's not very specific. A lot of it is left to the discretion of what in the first place, the House of Representatives chooses to do, and then ultimately what the Senate chooses to do. We don't even know for sure what the burden of proof is, whether the Senate has to prove, as they would in a criminal case, beyond all reasonable doubt, or whether preponderance of the evidence is enough. So I guess what I'm saying is there may be all of these kind of procedural matters that may get in the way of getting to what I think for most of us anyway is the central issue, which is whether President Trump's conduct was such that it constituted a high crime and misdemeanor, justifying not only his removal from office, obviously he's already gone, but also prohibiting him from ever seeking federal office again.
You've answered this question a little bit, but I want to go ahead because we do have a number of questions in the Q&A to weave them in as they're relevant to some of the topics that you raised. And one question was raised by your colleague, Professor Amy O'Connor in the school, and she asked, given the example that you used in class, I'm wondering if you think that the speaker was the president will influence how the courts might make a determination of incitement.
Well, I think a lot of what they were going to be looking at and what we already know the House managers are going to be bringing is not just what President Trump said, but how it was being interpreted by his followers. As most of you probably know, quite a number of the people that have already been arrested, who were part of the group that staged the assault on the Capitol, have been saying, my president told me to go there. I thought he wanted me to be there. I thought it was a patriotic thing to do because my president told me to do that. I am confident that the House managers are going to include evidence of that, probably recordings of that if the Senate allows it, to demonstrate that it wasn't just a question of Trump's rhetoric. A lot of the supporters of President Trump's over the years have said you should not take him literally or something like that. They are going to use that, I expect, as an example of saying Trump's followers do take him literally. They don't just think that he's speaking metaphorically about the need for a change in government or reform to the voting processes. He's saying, let's storm the Capitol. It'll be very interesting to see how that plays out. I can't predict it right now because I think we have to wait and see what kind of evidence is introduced during the impeachment trial.
I want to turn to the topic of Twitter and social media a bit. So one of the unique, incidents that occurred was that Twitter began suspending accounts. So did Twitter violate President Trump's First Amendment rights? What First Amendment considerations were there in this situation?
I'm so glad you're asking that question. I mean, it seems like people that do media law have been answering it for weeks, but it doesn't quite seem to be reaching everybody. So it's worth saying it right now. Because Twitter, because Facebook, because other social media companies are not owned and operated by the government, they're not even regulated by the government, except in some very incidental ways. This is not state action. And if it's not state action, that means that the First Amendment is not being violated. Now, I know people have been arguing not only are the speaker's First Amendment rights being violated here, but also the rights of those who would like to receive this information. I'm hearing that argument a lot. And those are certainly important rights. I don't mean to denigrate them in any way, but the fact of the matter is they aren't First Amendment rights because the government is not involved here. So to the extent that people are upset, they need to just recognize that what's going on here is actually something that the Republicans usually think is really important, which is that these corporations are making their own decisions about what they're going to allow without any kind of government input or interference.
Related to this, the move has caused many conservatives to leave the app, or at least talk about leaving the app in search of spaces to which they feel their ideas and speech won't be censored because of political bias, so finding a different market, so to speak. In addition to teaching media law, of course, you teach ethics. So were social media companies correct in suspending Trump's accounts? We teach account planning and strategy in our school as well, not only journalism. And so what were the ethical considerations that might be involved?
I think this is a hugely complicated issue because from a legalistic perspective, because I'll always start with the law, they're within their rights, and some would say their duty, to enforce their terms of service. Some of them, for example, have terms of service that say they will remove content that glorifies violence, or that engages in ethnic slurs or things like that. And it's interesting, and probably many of those viewing today know this, that just today, the new Facebook Oversight Board has issued its first report on several instances of content that was taken down. None of them involving President Trump. They're going to be considering the Trump issue later on this year. And they upheld one of them, but they said the others they should not have been taken down. And it's a complicated issue, and I don't need to go into it in detail unless somebody wants to ask. But my point is, they're struggling here to try to decide whether they're going to just be a neutral platform or whether they're going to engage in some kind of curating of the material that is there. I don't think there's any question, at least not in my mind, that a lot of their angst over this right now is economically driven. And that comes from a couple of directions. One is it's been very profitable for them to carry this kind of content. And number two, that because of the Section 230 to the Communications Decency Act, they've had little or no risk of any kind of liability for the content that is being posted. Because of the First Amendment and because of Section 230, it's going to be very difficult for the government to step in and try to enforce on them any kind of duty to regulate the content. I'm not saying there isn't a push to do that coming both from the Republicans and the Democrats, but it's going to be hard to do it from a First Amendment perspective. They could change the law, of course, but I think the more likely thing is what we're already seeing happening, which is that Congress and the Justice Department are going after these companies under the antitrust laws. The media companies are not exempted from the antitrust laws, quite to the contrary. So, and this is already happening in Europe, where massive antitrust actions are being brought against some of our big companies like Google. So I saw in the Washington Post today that Mark Zuckerberg is getting very nervous about what kind of antitrust actions are likely to come in the next few months. And they are kind of preemptively saying, well, maybe if we take this content down, that will deflect the government from coming after us in a regulatory way. I personally think that a lot of the problem for these social media companies is they don't quite know what they want to be. They provide news feeds, they curate material, they use algorithms to generate news feeds for their users. But in fact, they are not traditional news media companies. And I don't think they approach these questions the way traditional news media do. If they did, they would have been much more concerned about the misinformation and disinformation that was being spread on their platforms. At least in my opinion, that's what would have happened. But they chose to basically turn a blind eye to it for a very long time. Is it fair to hold them to the same standards we would hold a conventional news organization to? I don't quite know the answer to that. And another way to look at this, and this is something that there's a lot of debate about, is whether we need to think of these companies not as publishers, but as utilities. I mean, the equivalent of an old like AT&T landline telephone, where they will not have any liability for the content that moves through their platform, but they will also have no ability to edit it or control it in any way. And it's, kind of a Faustian bargain that I think they're going to have to make as they pick and choose between whether they want to be seen as publishers or creators of content, or whether they just want to be a utility company.
I think your comments touched on a few questions that our audience members have raised. So I'm going to read a couple of them off. One of them is from Susan Paston, who wrote in to say, if social media is so dominant that it's considered a monopoly, or at least part of a small oligopoly of companies controlling social media, should it be subject to more regulation, including regulation to protect speech? That seems to get at your utility.
And as I said, in Europe, this is already happening. There's been great consternation in Europe that these American companies are basically dominating the social media space, and they're making serious attempts to rein them in. I guess I kind of have mixed feelings about this. I think in an ideal world, when we think about sort of the cyberspace as a whole, it ought to be possible for other companies to come in and supplement these companies that are already dominant. I mean, we've seen a few created, as you mentioned in your opening remarks, Alicia, in the last few months. They have their issues including perhaps being deplatformed by Google Play or something like that. But in fact, unlike with the broadcast media, for example, the old-fashioned over-the-air broadcast media, where broadcast spectrum is limited, only one user can operate on a particular frequency. You can't say that about cyberspace. Anybody can be there. It's not even the same as cable companies in a particular municipality. If you still subscribe to cable in a particular area, you probably got one cable company that will offer you the service, and that's going to be it. But of course, more and more people now are going to streaming services or satellites, so they're not even using them as much as they once did. The point is that if there's a place for others to come in, then it's harder to argue that you really have a monopoly situation. Again, many practical obstacles to that. I'm not trying to suggest those aren't significant, but it's not the same as when you're talking about, for example, the broadcast spectrum. So I think it's going to be a difficult argument to make unless you can really ratchet it up to the point of saying, these are the only companies that exist. They're the only ones that can be financially competitive. And for that reason, as a public good, they have to be regulated.
Another former student in the school, Patrick Sharkey, raises a question about, what signal does this really send to the rest of the world? And he notes that to prospective journalism students, taking Professor Kirtley's class was one of the best educational experiences of my lifetime.
Thank you. Not everyone agrees with that, but
his question is this: how does the recent social media ban on Trump leaders affect calls for future bans? I'm most interested in calls from Russia, Putin, to restrict the speech of Navalny. It could be argued that Navalny and his cause to action would be seen as incitement to cause destruction. How are we a democracy model to the world, essentially?
I mean, you bet. I absolutely agree with that. Before COVID, I did a lot of work internationally. And one of the things that I was always so proud of was to say that we had such a strong presumption against prior restraints in this country, and how important diversity of voices were, and how the cure for bad speech was more speech, and all these things that, they sound almost like platitudes, but I believe them sincerely, and I think they are worth looking at modeling. But the problem is that now there's such a strong backlash to what has happened in the last few weeks, coming again from both sides, from people demanding greater regulation and greater editing or removal, or whatever term you want to use, calling for the government to step in and engage with this. The fact of the matter is, going back to what I said at the very beginning, we have a long and strong history in this country of protecting political speech, however offensive people may find it to be. And if we start declaring that certain kind of speech is tantamount, for example, to domestic terrorism, many of you have heard the calls for new laws dealing with domestic terrorism, because we actually don't have a criminal statute for domestic terrorism. Domestic terrorism can be added on to other crimes, but it doesn't exist as an independent claim right now. I would be very concerned about something like that, not because I thought anything that happened at the Capitol on January 6th was justified. I absolutely do not. Violent protest is not and should not, in my opinion, be protected by the First Amendment. But advocacy is another matter. And we've already seen, you mentioned Russia, but we've also already seen in other autocratic countries that simply speaking out against the government can be characterized as a threat to national security and can lead to people being arrested and jailed and so forth. And one of the things that is so concerning about this happening in the social media context is that we've already seen examples of some social media companies that are, for example, doing business in China, saying, well, we have to abide by the Chinese laws, and doing things like shutting down Zoom sessions where people were talking about Tiananmen Square that originated here in the United States because the Chinese considered that such disturbing content that it was illegal and couldn't be permitted. So I share the concern about that. I also share kind of the broader concern and Alicia and I talked about this a little bit earlier on before we began this program. I'm very worried about a backlash that is similar to what happened after the 9/11 attacks. Um, those of you that were alive then remember that one of the first things that happened was that the USA Patriot Act was passed, which gave sweeping new surveillance powers to our intelligence and security communities. Maybe justifiable, maybe not. But within a couple of years, people were looking back at these and saying, were these really a good idea? But the problem is that once the intelligence and law enforcement communities get powers to do things, they're very reluctant to give them up. They're like anybody else. So I guess my concern is that if we act too quickly in response to what happened on January 6th, we may end up with a new set of laws or a new set of powers that are given to law enforcement, which will actually curtail legitimate political debate and discussion, and characterize speech that today would be protected as either domestic terrorism or incitement. So I'm worried not only about the message we're sending abroad, I'm also worried about what we're going to do here in the United States.
I want to follow up on some of our earlier lines of questioning because we have some additional questions on it. And one question is from David Erickson, who was a former journalism University of Minnesota student. Thank you for joining us, David. He says that he learned from Professor Don Gilmore that the First Amendment freedom for incitement stopped at the door of crying fire in a crowded theater. I'm sure a lot of us have heard of that. How does that apply to what Trump, Giuliani, and others did with the crowd before they attacked the Capitol?
Well, thanks for the question. You know, it gives me an opportunity to remind everybody that it's incitement to shout fire in a crowded theater if it's not actually on fire. There's never been a prohibition on doing it in the context where you actually would be attempting to save life and property by alerting people to a disaster. But I think the point here is that the applicable test for incitement here is the one I described. It's the Brandenburg test. And again, it requires imminence, the idea that something is likely to happen and more than likely will happen, and that you're advocating that people engage in that right now. I mean, that's, I guess, if you're shouting fire in a crowded theater, the expectation is that people are going to start running for the exits, right? And bad things are going to happen. So if you do it falsely, you're in trouble. It's a little bit different with what Donald Trump was doing, because it wasn't a question of truth or falsity here. It was a question of what message he was sending to his followers. And as I said at the outset, you know, it's, if you look at the transcript of what he said, it's certainly possible to interpret it in a relatively benign way and to say that President Trump was just calling for a peaceful march to the Capitol where people would peacefully protest. But the argument that the House of Representatives is likely to make is that you can't just look at what he said there. You have to look at how he basically inspired the people to come to Washington in the first place. Many of them came armed, either with firearms or other kinds of weapons. They were revved up to engage in some kind of conduct. You know, he said he'd be marching with them. I mean, how do you interpret all of that? I think, again, I don't know the answer yet. I'm not prepared to say whether this is, you know, technically going to be found to be incitement or not. And the fact that it occurs in a political context makes it much more complicated than if it were not the case. The fact that he's the president of the United States certainly doesn't insulate him from the whole impeachment proceeding. But as I said, and I think we talked about this, Alicia, in order to be impeached, he does not have to be convicted of a crime. They don't have to meet the standard of convicting him of a crime to be able to impeach him if they have the evidence there that is sufficient to show that he committed a high crime and misdemeanor, which is not necessarily a violation of 18 USC of the federal code.
Thank you. I want to turn our attention back to social media a bit. We've received a few questions related to it, and they're great ones. So one question relates to the spread of misinformation, even disinformation on social media, which I also think relates to the tenor of the crowd and you know, people's willingness to to go to Washington, D.C. to begin with from all over the country. So an anonymous attendee asked the question, would it be unconstitutional for the FCC to fine news organizations for spreading false information, i.e. election results, or do we depend on private companies like Dominion to file defamation suits to hold news outlets accountable?
That's a great question, and there are many layers to this question. And I guess I'd like to start by kind of introducing my answer by saying we're in somewhat uncharted territory here when we move into the misinformation, disinformation area. As I said, there's established Supreme Court law about what constitutes incitement. There's established law about what constitutes a true threat. But historically, it has not really been the role of our courts to decide what is true and what is false in the abstract. I mean, they decide if it's true or false, for example, in the context of a libel case, because you have to figure out whether someone has been defamed in a way that is not protected by the First Amendment. Just calling somebody something bad doesn't give them the basis for a libel suit unless they're able to prove that it was false. So we're moving into new territory now as people start saying we need new ability to go after media outlets that are promoting or spreading false or misinformation, or individual actors, whether it's President Trump or one of his followers. This is a complicated question. Now, there are existing rules under the Federal Communications Commission dealing with broadcasters who fabricate news and who spread false information for the purpose of, again, alarming the public. So such regulations do exist. They aren't used very often, but they are there. False news, that sort of thing. But the important thing to remember is that for the most part, those apply to the broadcast media, not the cable media. And I think for most of us, the perception is that if there's an issue with this, it's arising more in the context of cable news than it is in the context or cable news or entertainment. Fox is registered as an entertainment company, but whether they are the ones that are purveyors of fake news of that nature, or whether it's the traditional broadcast media. I realize there are many people who don't trust the so-called mainstream media, but that's a slightly different question. The only other thing I would say is that as we look down the road in terms of options that Congress might have to try to address the concerns that many are raising, the Federal Communications Commission, as it stands, does not really have any kind of authority over the internet. Back in a case many years ago, Reno versus ACLU, when there was really an attempt to try to regulate the internet in the same way that the broadcast airwaves were, the Supreme Court said, no, the internet is like the printed word, which enjoys the highest level of protection. So the only time that these companies are subject to regulation is for things like that would be subject to existing law. For example, if you've got false advertising, the Federal Trade Commission can go after you, and you can't say, oh, I'm immune because I'm a social media company. That it doesn't work that way. So I think the question is whether do we need a new regulatory scheme to deal with disinformation in the media writ large, whether we're talking about the Star Tribune or CBS or Facebook. I mean, whatever it might be, do we need something like that? I just published a piece at the University of Chicago Legal Forum where I basically said, I don't think we do. And here's my concern. I don't feel comfortable with a governmental entity, whether it's the executive branch, the legislative branch, the judicial branch, being the arbiter of what is true and what is false. I absolutely recognize that people feel, and I feel this way too, that it's very difficult to know where you are these days because there's so much information and misinformation out there. People choose to go to the channels of information with which they already agree, and they're not being challenged. And this is a real issue for our society. And I don't have a great solution for that. Some of our other colleagues in the Hubbard School are looking at these questions in more depth than I am. But from a purely legal perspective, does anybody want a ministry of truth that's going to decide what is true and what is false? And before you answer that question, you have to also keep in mind that whether you're happy with whoever is in office today or not, the wheel will turn and the other side will be in someday. And are you confident that the other side will enforce rules like that in a way that will promote the free expression of ideas? So I worry a lot about any attempt to create a new legal regime that deals specifically with misinformation and disinformation. And let me just add very quickly that other countries are doing this, including mature democracies. Germany is one example. They're running into a lot of issues there because there are groups that are saying that, they're just stating another point of view, but they're being shut down because it doesn't follow what the conventional wisdom is. Again, I'm certainly an advocate for truth telling. I'm not happy with the idea that actors are out there deliberately putting out false and misinformation. And it's been going on for a long time. It didn't just start with the run up to this election. I think it's a real and genuine concern. And for me, one of the biggest solutions is likely to be better media literacy among the consumers of this kind of stuff so that they can distinguish between what's quality information and what's not.
We've had a few questions come in from Kathy. I'm not sure if I'm pronouncing the last name correctly, but I'll just say Ehlers. And they relate to this. And so I'll relay some of the questions and then we can kind of talk about how your recent answer relates to them. One concern was regulation. She says, isn't there a huge risk regarding the right to satirize when we restrict misinformation or disinformation? Or do we require or highly suggest labeling on this type of speech? For example, the Onion editorial cartoons. Is there a potential policy spillover into related spheres like theatrical presentations, live stage or film, video games, virtual reality? There's always going to be new media that kind of come up. And so how to handle free expression in them will always, require considering our Constitution and these new applications.
I think parody has always been one of the most subversive ways for those who are in opposition to whatever the conventional wisdom would be to express their points of views, whether it's political cartoons, whether it's satirists. I mean, we certainly saw it in the former Soviet Union, where that kind of satire was key to keeping people thinking about ways that they could make their governments better and more responsive to their needs. And yet that was something that often got shut down because it's very threatening to those in power. Laughter is a very, very powerful antidote to power. So I think, and I guess one other thing I would add, and my former current students know this, in the case involving the Reverend Jerry Falwell and Hustler magazine, the Supreme Court wrote a really strong opinion, not just protecting the right of Hustler magazine to make fun of the Reverend Jerry Falwell by depicting him in a satirical ad, satirizing a Campari liqueur ad, depicting him as having his first sexual encounter with his mother in an outhouse after they both kicked out the goat. Reverend Falwell sued Hustler magazine for infliction of emotional distress. He also sued him for libel and invasion of privacy, which not everybody remembers. The libel point I wanted to mention just quickly because the jury in Lynchburg, Virginia, which was a place that was certainly sympathetic to Reverend Falwell, said this satire could never have been taken seriously by anyone as any kind of statement of fact. And they threw that part out. And then ultimately the Supreme Court agreed that the infliction of emotional distress claim, the idea that it hurt Reverend Falwell's feelings, was not a valid claim either. And in that opinion went on at great length about the long tradition in this country, particularly political cartooning, but of any kind of satire, as a way to poke fun at those in power and also to communicate political ideas. So I think the question is going to always be, could it be taken seriously? Is it packaged in such a way that a reasonable person would understand that it was meant to be satirical? In the case of the Hustler case, they had labeled it multiple times in the table of contents and on the page itself that this was satire, not to be taken seriously. If your question is, are you going to need that kind of disclaimer anytime you engage in satirical speech? I would say that's probably already a good idea if you're targeting a particular individual just from a libel perspective. Whether ultimately that would be necessary in this disinformation context, I think it's probably too soon to say.
Related to that, it seems as though, and one of our viewers, Susan Paston, wrote in, would a possible remedy be if people directly harmed by deliberate disinformation could sue those propagating the false information? Reckless disregard for the truth is what she said she learned in journalism.
Well, and that's a great question, but again, it kind of flows from what I was saying before. The actual malice standard that you're alluding to, knowledge of falsity or reckless disregard for the truth, is relevant in the context of libel, and in some cases, in certain types of privacy cases. But it doesn't exist just in a vacuum. We don't really have a claim right now that someone could make to say, you didn't tell me the truth. Some people remember some years ago, there was a case called the Alvarez case that went to the US Supreme Court that involved an individual who I think was running for political office, who misrepresented a military citation that he claimed he had received that in fact he did not get. And there is a statute that says you're not allowed to do that. You're not allowed to claim that you win these, or I shouldn't say win, but are honored with these kinds of medals. And so it was challenged. And the Supreme Court ultimately said that there is value in falsehoods, actually, and that there was not a compelling enough interest on the part of the militaries to justify this kind of action against this individual. It was somewhat fact specific because it was easy to determine that, in fact, this guy had not received this particular medal. But the fact remains that the court said there are other options available to the military to deal with this. They can put out their own press releases saying this guy never got this medal, but to basically punish someone for telling an untruth in that context was not something that the court was prepared to sanction. So I think that might be a signal to us looking to the future that the court might be reluctant to say that there should be a cause of action for misinformation and disinformation, full stop. Again, if you think about some of the cases, and I don't know, maybe the questioners are thinking of this, like the ones that the Sandy Hook families have been bringing against Alex Jones and people like that for saying that Sandy Hook was a false flag operation and that it was all fake and so forth. That has really ultimately been put in the context of either libel or invasion of privacy, or perhaps infliction of emotional distress. It's not just a truth trial to try to determine whether the person told a falsehood or not.
We just, I want to turn our conversation a little bit to some of the ethical kind of contours of the moment. Michael Anderson has given us a question, an alum as well of our school. Do you think the new president or the Congress can or should do anything to reaffirm that the media are not the enemy of the people? Of course, some of the speech and what's going on right now has really placed journalists in the line of fire, so to speak, in this context.
I think the short answer is, of course, there are some things that the Biden administration could do. And in fact, the Biden administration has already done a couple of things. Reorganizing the leadership of the Voice of America, for example, which in my opinion had been totally distorted by Trump appointments, where he was putting in political appointees that were completely averse to VOA's mission. This is really important. Again, because of the work I've done in other countries, I know how important all the VOA subsets are, and maintaining kind of the idea that these are non-political organizations has been essential to their credibility. So that's one thing. I've been attending a conference the last couple of days with the American Bar Association, and there's a lot of talk about doing things like Congress should adopt a federal anti-SLAPP law, which would be a federal law. Many states have such laws now, but there's no federal law that would give people recourse when somebody including media organizations, when somebody brings an action that is really frivolous, simply with the hope that you will either drive them out of business or get a big settlement or something like that. The SLAPP acronym means Strategic Litigation Against Public Participation. If the Biden administration supported that, I think that it would be pretty likely to get through Congress. Federal shield law protecting journalists from being compelled to reveal their sources. A turn back from the kinds of prosecutions we saw for leaks that occurred, I have to say, during the Obama administration, continuing into the Trump administration. Controversial people like Assange and Snowden and so forth, whether they're journalists or not, it remains a subject of debate. But the related question is, should the journalists that they provide information to either be compelled to identify them as their sources, or should the journalists themselves be prosecuted under the espionage laws? I mean, these are huge, huge questions, very significant questions. And sadly, in my opinion, the Justice Department under President Trump was not terribly sympathetic to these concerns. So those are kind of the legal steps that I would foresee right away that might be helpful. But I think we can't discount just the power of rhetoric. Just to have somebody in the Oval Office who isn't calling the media the enemy of the people anymore would probably be a step in the right direction. Holding more press conferences, being candid in those press conferences. Of course, the Biden government has pledged that kind of candor and transparency. We'll see if it persists or not. I hope it will, but we'll have to wait and see. But I've always believed that what happens at the top does trickle down. And the message that the Biden administration sends, I think, will resonate throughout the country, in whether we're talking about Republican governors or Democratic governors, or we're talking about local officials. If they're watching and listening to what the President of the United States is saying, I think that will have an impact on their future interactions with the press. So I hope that the Biden administration will walk the walk in this area and continue to support these kinds of initiatives. And I'm sure there are others I'm not even thinking of right now that would be helpful.
Bastian Banneker has written a question. Are some of the core beliefs you mentioned earlier regarding freedom of speech under attack? It's my impression that many people no longer believe that more speech is a better way to deal with problematic speech than restriction. They do not believe that lies about the election can be counteracted by truth, and want these claims purged from the marketplace of ideas. Are you concerned that this reasoning could find its way into judges' opinions and weaken protections of speech?
I am concerned about that because, of course, judges are people too, and they too observe what is happening here in a general sense, and I think some of them find it very troubling. It's probably premature for me to make predictions about what the Trump appointees among the federal judges are likely to do going forward. I'll just give one example, which is related but not exactly the same. Justice Kavanaugh, when he was a federal court judge, ruled that the state versions of the anti-SLAPP legislation that I mentioned earlier should not apply in federal cases. That's eventually going to go to the US Supreme Court, and we're going to get that resolved. So I guess my point is that I think there are certainly judges that are also concerned, and it's not a new phenomenon, have been concerned for a long time, that the First Amendment gives too much discretion to the individual speaker, gives them too much ability to do mischief in ways that can be very harmful. On the other hand, I think that one thing we need to keep in mind is that libel laws that protect speakers against frivolous libel suits protect you regardless of what your point of view might be. If you're Sidney Powell, you are the beneficiary of the history of the New York Times versus Sullivan and its progeny just as much as somebody on the left would be. And I would hope that judges, and I think historically most of them have, will kind of keep their eye on the ball here and say, we have to protect speech that people find offensive, because if we don't, there's going to be a real risk of the judiciary, the executive branch, the legislative branch, essentially proscribing certain viewpoints as being unacceptable. And I'm sure there are people watching this right now who think they got their list of speech that is unacceptable. On the University of Minnesota campus, we've had this debate about hate speech and what kind of steps the university should take to curtail that. Maybe it's just a sign that I've been doing this kind of work for such a long time, but I maintain the view that the solution to speech that we find problematic is counter speech. Yes, it's hard in this cacophony of social media sometimes to find the right platform to do that. And I do worry about the fact that with the rising use of social media for people as their news source, they are, as I said earlier, choosing to channel themselves into those sources that repeat what they already say. They either deliberately or just by dint of consequence end up only seeing those things that reinforce the views they already have. This is scary stuff to me. I mean, it's not just a question of, it is a question of things that go to the heart of our democracy. Are our elections secure? Is there really a pandemic? I mean, these are critical questions that are going to mark the difference between whether we survive as a democratic republic or not. And I don't mean to suggest, oh, it doesn't matter, we'll just count on the marketplace of ideas for everything to wash out. But I guess I remain uncomfortable with the notion of any governmental entity deciding what kind of speech is okay and what kind of speech is not.
I just want to let everyone know who's listening, we have many more questions than we're going to have time for in the next 10 minutes. So I'm going to group several together that are kind of thematic. And so I appreciate the comments that I see from the questions from Patricia Arnold, Stephen Dornsveld, and an anonymous attendee. And they're around incitement. And since that was the initial topic of this webinar, I want to go back to it. So the questions are this: is incitement one of the simplest charges as far as ease of prosecution in the Senate that the House could have brought concerning the events of January 6th, or could the House have charged Trump with anything else that might have had an easier path to conviction? Do the comments of the other speakers, at the rally fit into the issue? Does that matter? Does it matter that the incitement was based on a false statement that he won the election by a landslide? Also, it would be unlikely, but if they desired to do so, could individual counties or state election boards sue Trump or similar in those in Trump's circle for libel or defamation, similar to suits that Dominion has filed? So that's a lot, but
that's a lot. But let me just answer the last one quickly, because the answer is, of course, they could. Now, again, because they are governmental entities, they're going to be having to meet the highest possible standard. But yes, it's conceivable. Again, this conference I was attending earlier today, media lawyers were talking about what they think is going to happen in these suits that Dominion has brought, both what they think is going to happen and what they'd like to see happen. There's a potential, if Dominion prevails in these cases, I think, to really do some major reorganization of the way we think of libel law, actual malice standard. One of the questions you ask yourself when you think about actual malice is, does the speaker have knowledge of what they're saying is false? Could an argument be made that some of these people that are making these statements aren't in their right minds, frankly, that they don't know what they're saying is not true. They do not have knowledge that it is false. They have become so brainwashed that they think they're telling the truth. Is that going to be a defense? I mean, to me, these are really fascinating questions. And from an ivory tower perspective, I think, it's great that this is going on. But I do worry, because I've been saying this for nearly 40 years. I don't think libel suits are the solution in situations where you're unhappy with political speech. I just think that there's too much of a risk that opposition speech will be curtailed or discouraged as a result. So while I can't predict what's going to happen with these Dominion cases, and smarter people than I am think that they've got it pretty nailed down in terms of it being assertions of facts that are false and were knowingly false. I always worry that even if the side you might be sympathetic with wins, it'll be making bad precedent for future libel cases. So I'm not sure if that fully addresses your question. In terms of the impeachment itself, if you look at the article of impeachment, it also it alludes to President Trump's phone call to Georgia saying, "Find me some votes." They didn't explicitly go after him in the article of impeachment for interfering with the election. That kind of surprised me because I thought that that would be a relatively easy thing to demonstrate and prove. I certainly can't explain why the House managers decided to just focus on the incitement. My guess is, and it's only a guess, is that they thought that, you know, what people saw with their own eyes in unfolding on January 6th and what they heard with their own ears would be irrefutable evidence of somebody who was deliberately trying to entice a mob of armed people to storm one of the coextensive branches of government with the idea of, at the very least, disrupting the lawful business of Congress in certifying the election. You know, interference with the election process and so forth is part of the way you can argue for things like insurrection. Probably a lot of this is going to come out in the trial. The fact that the article of impeachment is really just styled as incitement for insurrection, I think, can actually encompass many of these things as they go forward.
Another question that we have from Catherine Cleary was, how would you respond to Josh Hawley's cries of anti-First Amendment rights when his publisher withdrew his book from publication and other outlets disassociated themselves from them? Where is the line? I think that there have been some consequences to those who have participated in the insurrection, regardless of whether or not they're part of the impeachment trial or sued.
Right. Well, you know, the thing about the First Amendment is, first of all, it only prohibits the government from punishing you. And of course, that can include using an instrument of government like a court to bring a suit against somebody. But, you know, freedom of speech is not freedom from the consequences of your speech. And the fact that there may be negative consequences to somebody's speech is not in and of itself something that the First Amendment has a problem with. The original idea behind the First Amendment was that you could not be prohibited from speaking, absent one of the exceptions, such as the incitement that we've talked about today. Hawley's just wrong if he says that the First Amendment is violated when the publisher decided that they didn't want to publish his book. I believe he has another publisher now, which is the whole point. They are companies, they're non-governmental, they have every right to choose whether or not they're going to publish his book or not. I don't know if they violated their contractual arrangement with him. If they did, he could probably sue them for breach of contract. But there's no First Amendment violation here. If you think of it more in the broader context of free speech, the fact remains that there's well-established law in this country that says that publishers can't be forced to publish things they don't want to publish. This again goes back to this idea that, again, the Republicans usually seem to like, which is that the private industry should be able to make these decisions for themselves. And arguably, that's all Simon & Schuster was doing with Josh Hawley's book.
And then related on norms, there's a question from David Erickson. Is there any continuing constitutional requirement for a former military or law enforcement officer to follow when they violate legal norms, as some allegedly did during the January 6th attack on the Capitol?
Well, I'm not an expert on that. I will just quickly say that to the extent that they're engaged in peaceful protests, there's a body of law, a body of cases that go to the question of whether public servants basically check their First Amendment rights at the door by virtue of being on the public payroll. And the short answer is sort of, in the sense that if a government agency is able to show that the speech or expressive activity they're engaging in is kind of contrary to what they're supposed to be doing in their official role, then that might be grounds for discipline or firing. But if it's not, if it's unrelated to that, then the government can't do anything to them. So I think the shorter answer is, if they were to say, for example, going into the Capitol carrying a Confederate flag, threatening members of Congress, that's contrary to what we want a police officer from any town USA to be doing, the likelihood is that that would be something that would be permissible. It's not without its problems, of course, because we want people to be able to engage in political speech. It requires a really subjective analysis, frankly, on a case-by-case basis.
Well, I see that we're at the end of our hour, and I just want to thank you so much. And maybe one last comment on a broad question, which is how might we as individuals on a policy level in Congress, or even as educators or people training journalists, protect the marketplace of ideas? Do you have any closing thoughts on that before we end this soon?
Well, the Society of Professional Journalists Code of Ethics has as one of its core tenets that journalists must seek truth and report it. And when I look at the comments that people put on news websites, occasionally you'll see something along the lines of, I just want the news media to tell me what the facts are, not to tell me what to think about them or what they think about them. And I think there's a lot to be said for getting back to those core values in our news reporting and even in our analysis. Also holding our competitors and our colleagues' feet to the fire if we think that they're not being truthful. I think again, there's a lot of infighting going on, obviously, and a lot of factionalism and tribalism in this country. We need to get to a place where we can agree on a set of facts. And for that, I think something that a university like this one can be doing, regardless of what the major of our students will be, is to teach them critical thinking so that they can discern between those sources that are valuable and those that are less so.
Thank you so much, Shane. I couldn't agree with you more. And I want to thank everyone who stayed with us through the hour. It was wonderful to see you. Please join us again for our future webinars and events that are part of this series. We appreciate your time, and we will see you in the future.